My name is Mwenda, Tevin. I'm an advocate of the High Court of Kenya. I specialize in data protection and cybersecurity matters, particularly in policy creation, policy and research. Today's presentation will focus on the Gdpr, that is the General Data Protection Regulations, and the creation of websites. So we're going to look at the effects that the Gdpr has on the creation of websites. Yeah, so I think I'll just go into the presentation. So the first thing we look at when it comes to the Gdpr, you have to realize the purpose of the Gdpr. And the purpose of the Gdpr was to create accountability. So the Gdpr came into place in May 2018. So now I think we're celebrating its third year since it came. And in accountability, the two main things that it set out to achieve was one, is to ensure that data controllers and processors safeguard their personal data, safeguard the personal data of data subjects, and also to ensure that data subjects have control of their data, kind of reclaiming the ownership of their data from technology companies. And in this case, it's data controllers and data processors. So the second thing that we look at when it comes to websites is the collection of content. In most cases, when you're creating a website, you'll have spaces where you'll want some form of data from the person, depending on the data you're collecting. So this will vary. In some cases, you want maybe information to contact them. If it's, let's say it's a website to do with healthcare, you may want their data on healthcare. If it's a website for registration of information, you may want some form of information. If it's a website you're creating for e-commerce, there are some details that you'll get. So in most cases, when you're having a website, you may end up collecting some data. So what should you look out for under the Gdpr? So the first thing you should be clear of is the lawful basis of why you're collecting this data. So the Gdpr provides for 6 lawful bases. The first one is consent. That is, the person has agreed for you to take the data. The second one is a contractual obligation. You need to fulfill a contract. And that's the one that most websites actually use as a way of collecting this data. The third one is legal obligation. So the law requires for you to collect this data. You may see, like, for example, if it's a website that collects financial data, there are some requirements that, let's use the example of Kenya CBK, may require you to have. So that will be a legal obligation. Vital interests. There's a public task that you need to achieve. In this case, something like if it's voting, you see the public task is that essence of voting. So you may need to collect some data to enable someone to vote. Legitimate interests of the person. So when it comes to consent, specifically, the Gdpr states that it must be voluntary and it must be intelligible. You can't just take data from someone and claim that they've agreed to it without proving that they have agreed to it, because the onus is on you, the data, you can say the data controller and processor, to show that this person consented to the collection of this data and they understood what they were doing. So an example would be, you can't just have a pre-ticked box of a collection of something. Maybe you want their phone number. You can't just be like, I'm collecting it and it's ticked. No, they have to agree to that. And you have to break it down in a way that they understand what it is that they're collecting, what it is that you're collecting, so that before they consent. So the different ways that you can enable consent. So consent can be maybe verbally, but you have to show. The trick with verbally is now you have to prove that they actually agreed, they actually said yes. It can be in writing. So you've seen in websites sometimes after towards the end of the website, it's I consent to this data being this. That can be a valid form of consent. It can be sticking a box on a web page, or by choosing a different technical setup that you may feel is appropriate from your website. However, whatever setting you choose, by the end of the day, you need to have in mind that you need to prove that the data subject actually consented to you taking this data. If the data is collected is of sensitive nature, so the Gdpr contains data that is classified as sensitive data. So sensitive data will be data around someone's sexuality, someone's healthcare, religious affiliations, their political stand. So such data is classified as, also biometric data, is classified as sensitive data. And for this one, you need explicit consent from the person. It has to be clear and equivocal that they have agreed to this consent, because generally, under the Gdpr, you're not allowed to collect sensitive data. The only other time also that you can collect sensitive data would be If the data is needed for a specific legal right, for example, in employment, you might find if you're creating a website for in relation to employment, there are certain things that the employer may want, even when you're filling in, let's say it's a job application, so they'll need certain data. If it's needed to pursue a legitimate interest, to protect the virtual interest of somebody, maybe by that data is important to protect them. Let's say if they're sick, for example, and you may require such data to enable maybe the cure to treat them, so that you might find you're protecting their vital interest. If the data is publicly available for furtherance of a judicial proceeding, and also for public health reasons. Good example with COVID, you've seen the government, if you go to like the portal for vaccination or for testing, there's certain data they collect, and you see the end goal is for public health reasons, is to see, okay, how many people have COVID, how can we track, how can we maintain this. So if it's for that, then you'll be allowed to take in sensitive data. So the third thing you should know when it comes to, still collection of content. The Gdpr provides for, if it's children under the age of 13, and your website maybe caters and is designed for children at the age of 13, consent is required from the parent. That's the general minimum for GDPR, but you'll find for different countries, because GDPR is mostly, it's European-based, even though it applies extraterritorial. So as long as you're working with people in Europe, GDPR will apply to you. So you'll find different countries vary in terms of the age of consent that they give, but the minimum one that it's given is 13 years. So if you're collecting data for any child below the age of 13, you require the consent of the parents or the guardians. Another thing, website developers should also develop policies that articulate the purpose of why they collect the data. So whenever now you're developing websites, you may be required to have both policies and notices. Policies are your internal mechanisms, like how do you collect the data, what is it for, how do you process it, the responsibilities each person has, how do you conduct audits in terms of data. So those are things that now you should be aware of when you're creating websites, and also when you are running a website for any particular purpose. You should also be required to formulate notices. Now, notices is what you share with the person. For example, if I log into your website, I expect to see a notice on how you use my data. I expect to see a notice on cookies, your cookie policy, how you use your cookies and the policies you have for cookies. So when it comes to website development, you should know that you should have your own internal policies, and you should also have notices, and which now are geared to the people who are accessing your website. So we'll come to that later on, the things that are required to go into the policies and the notices. So the next thing that you should consider, in most cases when you're developing a website, nowadays, in most times you may develop a website for marketing purposes. You may want to be able to share maybe some of your products with the person who's accessing your website, some of the things that, for example, sending them emails, promotional emails. And so the GDPR mandates that for marketing purposes, you should provide opt-in, not opt-out. So what this means is, under the GDPR, is for every consent that is needed for your website, the person should agree to it first. It shouldn't be by default that they found themselves in it. For example, I shouldn't find myself when I'm logging to your website that the next thing I get is maybe adverts about your products, or you're sending me promotional messages, yet I did not consent for that. So when it comes to opt-in for market purposes, you should ensure the following: that opt-in is given freely and consent fields are pre-filled, what I've just highlighted. So that consent should come freely from the person. You should unbundle consent. By this is, don't make the person consent to everything at once. So I call this progressive opt-in, where depending on the stage they're in on your website, you provide a specific opt-in for that. So if they log into your website, the first thing maybe that will come in is the cookies, which ones do they accept. So in this case, I'll advocate for the basic cookies that enable for the website to work. Then later on, maybe if they want to maybe purchase something on the website, let's say it's an e-commerce website. At that point, then now you should again put a pop-up and be like, we're going to collect financial data for you. So we're going to collect this. Do you consent to this? Okay, they have consented to it. The next point is, we need to send you whatever it is you've bought. So the next thing we need from you is your location data. Do you consent to that? So the consent is more of for every step that they go, rather than bundling everything at once. Because sometimes you see people develop websites where they say we shall collect all this information from you, and you see from the side of the data subject, they may not have time to read and understand what it is that they have consented to, which now creates a problem for you. Like, did they understand what they're consenting to? And the onus will be on you to prove that they understood what they were consenting to. So another thing you should do, after you put in your opt-in mechanisms, you should have an audit trail. And this is important to protect yourself in case the data subject is like, I didn't consent to this, or I didn't see the opt-in mechanism that you said. So you as a website developer, always make sure, the key thing with the GDPR, always make sure you back yourself up with an audit trail, so that you can, in case anyone complains, any data subject complains, you can, like, here it is, you ticked this box, and we had provided you with all the information needed before you ticked in this box. Consent should also be easy to withdraw. So nowadays, even if you're developing a website, after, let's say someone has consented to receiving promotional messages, on your email at the end you should have a button that's easy for someone to just press and say, I want to unsubscribe from getting this information. And it should be that easy. It shouldn't be that they have to go through all over your website to find, how do I unsubscribe from these marketing messages? How do I unsubscribe from getting these promotional messages? No, it should be as easy as just them opening a website and going to, even if it's at the bottom of a website, and clicking unsubscribe. So I'd earlier alluded to privacy notices and policies. So that's another key thing when it comes to website developments, the GDPR mandates. So what should be in your private notice? So a private notice, first of all, is a document that informs the data subject things regarding your website, basically things regarding how you handle data on your website. So some of the things you should contain in your notice are: who is collecting the information, what information is being collected, how will it be used, who will it be shared with, are you sharing that information with any third party, and who are these third parties, how will it be used for marketing purposes, and where will the data be stored, what security measures are in place to protect the data, the rights of the data subject, how does an individual request for deletion of the data, or to see the data that you have on them, how your website uses cookies, but it's advisable that you have a separate cookies policy, and how do they contact you. So all that needs to be in your policy nowadays because of the GDPR. And if I'm logging to your website, I should be able to see all that information before I consent to anything that you want me to do or to engage in terms of your website. So when it comes to website cookies, basically it's generally regulated by it's called the e-privacy directive, but the GDPR mandates that if your cookies can be able to identify any person, GDPR will also come into play. And when it comes to cookies, GDPR mostly advocates for opt-in. That's why if you log into any website nowadays, everything they say is, do you accept the use of all cookies? Do you accept use of analytical cookies? Do you accept use of marketing cookies? And that's because the GDPR mandates that for every time someone logs into your website. So generally, it's advisable that the cookies that you make mandatory are the basic ones that you need for your website to run. But everything else from analytical to marketing, it's advisable that you make them as opt-in, as options so someone can log in. So when it comes to cookies now, your website should have the following. Whenever someone logs in, the first thing they should see is, you should tell people that your website is using cookies. It can be even a pop-up like, this website uses cookies for this. So you explain what they are doing, what all those cookies are doing. This is what we collect for this. Then you can get the person's consent to store the cookies on their device. So in most cases, when you see the pop-up, can be I accept all, or I only accept some, or I deny all. And then you give information on the effects of all those three. So that can also qualify now as having now a cookies policy, because now you're explaining what you're doing in each of them. So the other thing you should consider under the GDPR when it comes to websites is privacy by design. So privacy by design is an approach of system engineering that seeks to ensure protection of privacy of individuals from the beginning when you're formulating your website. So immediately you start formulating your website, you should have privacy by design. And some of the things the GDPR mandates that you should consider under privacy by design is be in line with privacy design principles. So some of the principles you should consider are when developing your website, you should take a proactive approach in ensuring that there is data protection at the core of your design of your website. So whatever sites you're using or whatever APIs you're using to develop your website, make sure that you're taking a proactive approach of ensuring that it's data first. Privacy by default should be the setting. Someone shouldn't be struggling to, when they're on their website, to find ways of protecting their data. No, it's immediately you're designing it from the ground up, you should ensure that privacy is what's coming in as number one. Yes, privacy will be embedded into the design, so almost similar to having it as a default. You should ensure end-to-end security, so things like data, things like principles of data minimization, things like what else can I? Pseudonymization of data. So all those things you should consider when you're designing your website. So visibility and transparency. Be clear on your website, like how you're designing it, the systems you've taken, the things people should consider. So from the start of when you're developing the website, those are things that should be in your mind when you're developing. Like, at one point I need to have a notice. I should have cookies in place and a cookies notice in place. Yes. Then respect for users' privacy. So back to what I've just discussed. So at the core of your website design, privacy should be the main thing. So now we move to website security. So yes, you've designed your website, you've put privacy by design in mind. When it comes to maintenance of your website, you should always ensure that it's top notch. So you should always ensure that you always have security. And the things Gdpr mandates that you should consider, you should take into account the technology available, the cost of implementation, the nature, scope, and the type of data you're handling, and you should implement appropriate technical and organizational measures. So this applies for both website security and also privacy by design. So those are the things you should consider when you're doing both. Then another thing that you should consider is that your website at any one time, people should be able to trust it. So there is confidentiality, there's integrity, the systems are always up to date. You're using what is currently available in terms of ensuring that your website is secure. Because in case anything happens, let's say there's been a website breach or there's been a breach on your website, some of the things they'll be looking at if they're investigating is, did you take the necessary steps and did you use the available means at the time to ensure that your website was secure? And then you should also regularly test your website, assess it, do audits, do security audits on your website. Also, for the people who are working on your website, make sure they understand the importance of data protection. Conduct basic trainings on cybersecurity, for example. On some of the steps you should check, things like two-factor authentication, that's important. Things like don't click on fishy emails. So all that comes in terms of website security, because those are the things they'll be looking at in case you have a data breach. Let's say it's a company and your website was breached. Those are the things they'll be looking at, like, did you train your people on ways that they can protect the website? Did they take all the necessary measures that are currently there to ensure that there's security in the website? Then we look at now the implications of the GDPR on data breaches. So the GDPR mandates that in case there's a data breach, it's either the fine will either be 20 million euros or 4% of your annual turnover. Whichever is higher, that's what they'll go with. And in case there's a data breach, the GDPR mandates that you should inform the authority, in this case the Data Protection Authority, within 72 hours. That there's been a data breach and what has happened. And if you're dealing with sensitive data, you should inform the data subject as soon as possible. Any data generally, but sensitive data is held to a higher regard. You should inform them as soon as possible that this is a data breach and this is what has happened. And failure to that can also lead to fines. And also another thing now you should consider, due to now such fines and also issues around web security, when it comes to website development, let's say you're developing the website for someone else. In your contract, you should be very clear on who will be liable for what. And the reason why this is important is because when such a breach happens, you see, the authority will require to know, who am I going after? Am I going after the person who developed it? Am I going after the person who now owns the website or the person who commissioned the website? So you should be very clear on where the liability lies when you are developing your websites. Yeah, and that's the end of my presentation.